Welcome. If we haven't already met, my name is Ruben Rojas. I am an attorney in California, relatively new to the industry and going over some cases like I used to in the past. If you haven't already seen my first video, that one covering torts, then here's a quick little recap. Law is very complicated, like as an industry, and it doesn't have to be. The reality is that in the United States, we expect everyone to function as if they know quite a bit about law. They are responsible for following laws, uh, which are essentially rules, if you will, as if they understand them very well. And if you don't have a foundation, you're gonna find yourself in trouble. And when that inevitability occurs, you're gonna be stuck. You're gonna have to hire a lawyer, and you're gonna be kind of be at the mercy of the system. So having a foundation really helps a lot. To an extent, these videos are a way for me to pay it forward, if you will. It's what I would have wanted somebody to do for me when I was still in law school. See, there is a lot of companies who do summaries, which are extremely helpful, by the way. Shout out to Quimby. They absolutely saved my life in law school, like all 3 years. If it wasn't for them, I can pretty much guarantee I probably wouldn't have ever graduated. But I really needed somebody to do that extra step. See, a summary helps for you to know generally what happened, but you kind of need somebody to help you with understanding what it is that you're reading. Because law school classes require you to know a little bit more in depth than just the general facts. You need to figure out, how do you get to that? How do you get from the raw text of what occurred in court to that distilled case summary? And I haven't really found anybody that does that. So here I am. As you'll see, my general method is really just going online and looking up cases. And the same cases, by the way, that you would have seen if you were in law school, like exactly the same. Let's see, learning law hasn't really changed. We do it pretty much the same way now as we did, well, for the most part, for 200 years. And it's even really some of the same cases. So I feel like it's time for us to give it a little bit of a technological update. And that's why we're here. So there is a website who does these kinds of things. It's called opencasebook.org. By the way, cases are public information. If you know, we didn't know, which this is gonna sound crazy, but when I was new, I didn't know that either. So you're expected to be able to abide by the rules, and that's why they're public. So at least the raw content is public. Case summaries and stuff like that, there's extra work in there. So those are paid for, but that's a different story. As I mentioned in the first video, the format for these are going to be very different. See, unlike some other more distilled channels, I'm not really going to cut a whole lot out of these videos for the plain and simple reason that learning takes practice, and you're going to make mistakes, and people need to know that it's okay to make those mistakes. If we don't set that example, then we put this expectation of, if you're not perfect the first time, then you just can't do it. You just don't belong here, kind of thing. And personally, I just don't think that's right. That's not the way people learn. That's not the way that this industry works. One of the very first things that they teach you in law school is not to be embarrassed about asking questions that might make you feel dumb, but really it isn't, because it is a very complex subject, and you have to humble yourself to be able to ask those kinds of questions. See, law school, as I explained in the previous video, is done by a method called the Socratic method. And it's an old method done by Socrates, where he, just as I said in the last video, he was a very chaotic instructor in the sense that he never really gave you a straight answer. He taught by making the student think through the problem. The problem is, you need to have some sort of basis for how to do that thinking. And if you just throw the problem at somebody, It's like pushing them into a pool and seeing if they swim or they drown. And maybe that works well for competition, but if you really want a general population to learn, you're gonna have to do a little bit of instruction first. Law school doesn't really do that, at least not in my experience. They just kind of throw you to the wolves and see who lives, right? Survival of the fittest. And you even see it in the grading. We have something called the curve. It's quite notorious, and it operates on the principle of like a race, right? Like whoever does the best gets the A, and they're limited. Just like in a way that in a race, like somebody's gonna be first and somebody's gonna be last. So no matter how good everybody in the room is, there will always be somebody who gets an A and somebody who gets an F, generally speaking. There's some like minor exceptions in the like later courses where instructors don't have to fail people, but like in the first year, yeah, it's like real it's like real Hunger Games, you know. Well, I'm not about that. And so, as you'd see, especially in the first year of law school, like people don't really help you. Um, they're really just kind of there to see, you know, who can help themselves, kind of thing. And so nobody really gives you the answers. That said, this is a bit of a cheat sheet. I'm gonna give you the answers. I'm gonna give you the answers by letting you see what I see and what I think as I read a case, as if it was the first time. And for a little disclosure here, I haven't seen some of these cases in like 5 years. So it will feel a lot like I am reading them for the first time. So this is a great refresher for me. That said, like I mentioned earlier, I'm not going to cut out a whole lot. Like, unless it's super distracting, I'm just going to leave it in there. So cheers to chaos. Here we go. All right. So today we're going to be covering one of the first cases that you would see in a law school class under a criminal law course. Now, criminal law is one of those. It's one of those subjects that like law school just really finds to be so sexy. It loves criminal law. Like it really glamorizes, especially the prosecutor. Like there's three sides to every story, and I mentioned this already, but I'll just do a quick recap. There's the person doing the suing, there's the person being sued, and then there's the judge, right? And in a criminal law case, the person who's doing the suing is the government. Yeah, let that sink in for a second. The person doing the suing is the government. So law schools glamorize the government suing its people. Yeah. Yeah. And they do it, you know, in the interest of justice. Most of the time, usually, I'd like to think, maybe, I don't know. It depends on what day of the week it is. That's the posture, at least, right? So, yeah, that's the best way to describe it. That's the posture. Law is, particularly criminal law, is set up in a way where it's a balancing act, right? Like the people get the rights. You know, the government is restricted from doing certain things and from prosecuting a case in certain ways that give them a lot of power. And that's one of the reasons why we have things like juries, right? Where they are to serve as the conscience of the public. Like, listen, if you don't have if someone is being accused of a crime and they are not involved in they don't have a jury to decide the facts of the case and it's being decided by a judge, there's a pretty good chance that person's going to jail. Like, guilty or not, that person's probably going to jail. Because judges have no patience. Like they see through all the stories, you know, they come to quick decisions. And that's one of the reasons why people have the right to a jury trial. Now, it's a little bit more predictable what the outcome will be if a judge was to be the fact finder, but that predictable is you're probably going to be ruled as being guilty. The punishments might not be as overly severe, if you will, like they're more accurate about the punishments, but yeah, you're probably going to be in trouble. That's just the reality of it. And it's I'm not going to get too far into who said this, but the reality is that there's so many laws in the US. It's crazy how many laws it is that we have to abide by. And it doesn't matter if you know what the laws are. If you violated them and they don't require you to know to have a like a guilty conscience, like as far as the law is concerned, you're a criminal, which is very heavy-handed. But how do I say it? It's like it's only a crime if you get caught, right? Like, which is a horrible way to say it, but that's the reality of the system. And that's part of the reason why we have lawyers, right? To on both sides, for the government to protect the interests of the general population, and for the person who is being accused of the crime to only be held responsible for the crimes that they should be held for. So while law school loves to glamorize the prosecutor, in the role of the judge as well, but really the role of the prosecutor as far as criminal law is concerned, like if they have a basis for saying that you did a crime, like that's probably going to be the answer. Which is funny. It took me a while for me to get it through my head, particularly in the first year of law school. But yeah, the answer to the question is almost always going to be this person's guilty. And that's the way you have to look at it, right? You have to start from this person's guilty and then walk your way in the opposite direction as you go through the essay prompt. So you have to go in assuming that they're guilty and then trying to prove that they're not, which is not the way it's supposed to go. It's supposed to be innocent until proven guilty, not guilty until proven innocent. Yeah, that's another factor that we should really be considering, right? So as one of my instructors put it, and again, I mentioned this in a previous video as well, the way that cases are built are one brick at a time, meaning a little piece of evidence, right? So if you think about a brick wall, like it's got a bunch of little pieces in it, right? And the job of the prosecutor is to grab a piece of evidence, each of which is a brick, and set it down and grab another piece of evidence, which is another brick, and then put it right next to it, and then put it in right next to it until it stacks, and then you eventually have a wall. But if the prosecutor picks pieces of evidence that are, broken, they're cracked, or maybe they thought they had a piece of evidence, like it looked like a brick wall, but it turned out to be like a Lego piece, it's not going to hold up the same way, right? And so the role of the defense attorney is to look at the bricks that were used in building that wall and then say, hey, judge, look at this brick. Like, that's not even like a real brick. That's, made out of cardboard. Or, that's a Lego piece. That's not a real brick. Or, hey, they built this wall, but they forgot to put a bunch of bricks over here. Like, and they're supposed to like try to like basically grab a stick and poke at the wall and see if any of the bricks fall out. And if the bricks fall out, then they have to point that out to the judge and to the jury. Say, hey, you know what? Like, this prosecutor made it look like this brick wall was built like a brick wall, but it's really just paper mache. Like it just fell apart. And that's really the role of the defense attorney. And the role of the judge is to make decisions on law, like assuming that there's a jury, because frankly, if someone is being accused of a crime and they don't call for the right to a jury trial. Like that's either a very tactical decision or a really bad decision, right? Like if the judge is deciding on the facts, it's either tactical or it's not, you know. And there are times when you just want the judge to do it, like um, because it would be more predictable for one, and it would make the case cheaper. So if you don't have a big defense budget, like let's say someone is being accused of a crime and they don't have a lot of money to work this defense, and they kind of just want they just kind of want the verdict to be relatively quick. Um, that might be a reason to do it. I don't know. I'm not. I don't practice criminal law, so you'd have to ask somebody that does that. But it's something to think about, right? So that said, today we're going to be looking at People versus Decina. Again, one of the first cases. I did get this from Open Casebook. If you're a 1L and you need some summaries, I believe that they do summaries, so you should definitely check it out. You should also check out Quimpy. They also like make videos and stuff. It really is amazing. Like it helps out a lot. So whenever you look at these cases, you should always know when it's happening and where it's happening. So this case was in 1956, right? We're in 2025. Like it's been a few years, so some things may have changed. And the way that cases are built, it's like building a program in the sense that there's revisions. So there's 1.1, 1.2, 1.0, 2.0, 2.5. So whenever a case is completely overturned, that would be like an absolute new version of the way that the law is being done, right? Like there's been plenty of cases. For example, I think a recent one, like Roe versus Wade, right, was relatively recent, completely overturned. That would be essentially like a new version. It'd be Roe versus Wade 2.0, right? Not 1.1, right? Whereas whenever there's little pieces built onto it, would be like a minor revision, right? So this was in 56. This is in the New York Court of Appeals, which is much higher than actually like where New York's a special world in the way that they name their courts, right? It's not like trial court and then appeals court and then Supreme Court. Like for them, the Supreme Court is actually the lowest, and I believe the Court of Appeals is actually their highest. So this is not, well, yeah, it's not like the same, right? Okay, whenever you're reading these cases, by the way, you always want to start at the end. I know it's like, if you've been practicing law for a while, or if you've been a law student for a while, you already know that. But again, I'm kind of speaking to myself as if I was brand new as a 1L again, a brand new law student. I didn't know that. Like, yeah, you want to start at the end of the case. You want to know what's going on here, like the name. You want to know when it happened, where it happened, right? Or in this case, where it happened. This is second district. But you want to start at the end at the opinion. And how you know, by the way, if the opinion has started is you see a judge's name, right? So Desmond, right? J, boom. And they're also concurrent. Let me just see. Was there another person? Was that a concurrence? I am blinder than a bat, by the way. That's why this text is so big. In case you're wondering, you're just like, why is this so freaking gigantic? It's because I like big text and I cannot lie. That's why. Oh, actually, did they just jump into it? Oh, okay. No way. Did they really? Okay, I guess actually the opinion just started like right at the beginning. Okay. Normally there's a bunch of facts first. And it's really better to just go to the opinion first, like see what the judge came up with, and then look at the facts and try to reverse engineer their opinion based on the facts. It's not it's such a strange way to do it, but uh, because the way that law school looks at it is the law is always right, and regardless of what your opinion is, and regardless of what is actually correct, because sometimes these judges get it terribly wrong. Uh, they're not perfect either. They're people. They are definitely people. And so sometimes you look at this and you're just like, man, that was wow, why? And sometimes that could be, just people being a product of their time. It's 56. Like if 1956 was a different world than what it is today. Let's be honest here, right? Like things were a little different back then, for the better or for the worse. And so people are going to base their opinions, and they're going to excuse me, they're going to decide how they're going to do things based on that, right? Based on their surroundings and what's going on in the world. So some of this stuff is just like not. It's not actually legally wrong. It's just different from how we would interpret it today, right? And then there's some others that are just absolutely actually legally wrong. And maybe, not maybe, in some cases, that is exactly why it gets appealed. So you might look at, in law school, it's almost always going to be Supreme Court decisions or appeals court decisions, right? So that's as correct as it will get. But if you get the chance, you should definitely also look at what happened in the trial court. Like you really want to see how law was built, go look at how it was done in the trial court and like why it got appealed to begin with. Like in the very last one we talked about a tort case, and they talked a lot about like, okay, well, the appeals court said this and we think they got it wrong. So this is the new law now. And that's kind of that, version 2.0, right? And sometimes, I don't want to say rarely, because there's like politics plays such a huge role in law, and it's not supposed to, by the way. Like judges are supposed to keep their political opinion out of cases, but they're people, and they have their opinions, and that's to an extent why it's called practicing law, right? Because you never quite get it right. And sometimes their internal politics get in there, Okay, let's get into it. So it looks like Justice Frossel at about 3:30, okay, this was the opinion. At about 3:30 p.m. on March the 14th, 1955, a bright sunny day, defendant was driving alone in his car in a northerly direction on Delaware Avenue in the city of Buffalo. Defendant's car swerved to the left across the center line in the street so that it was completely in the south lane, traveling at 35 to 40 miles per hour. It then swerved sharply to the right, crossing Delaware Avenue and mounting the easterly curb at a point beneath the viaduct, and continued thereafter at a speed estimated to have been about 50 or 60 miles per hour or more. Okay, so this was in a street, not like a highway, and they were going first 35 to 40 and then 50 to 60. Okay, all right. A group of 6 schoolgirls were walking north on the easterly side of the Delaware Avenue when a defendant's car struck them from behind. Okay, one of the girls escaped injury by jumping against the wall of the viaduct. 3 of the children, 6 to 12 years old, were found dead on arrival by the medical examiner, and a 4th child, 7 years old, died in a hospital 2 days later as a result of injuries sustained in the accident. After striking the children, defendant's car crashed through a brick wall of a grocery store. To one witness, he appeared dazed, to another unconscious, lying back with his hands off the wheel. Various people present shouted to the defendant to turn off the ignition of his car. And within a matter of seconds, the horn stopped blowing and the car did shut off. Okay. Defendant was pulled out of the car by a number of bystanders and laid down on the sidewalk. To a policeman who came to the scene shortly, he appeared injured, dazed. Another witness said that he looked as though he was knocked out. An injured customer in the store, after receiving first aid, pressed defendant for an explanation of the accident, and he told her, "I backed out. What? I backed out from the bridge." Okay, at the hospital in Decina. Who still felt a little dizzy or blurry, said that he was driving at the hospital, Decina, who felt a little dizzy or blurry, said that as he was driving, he noticed the jerking of his right hand, which warned him that he might develop a convulsion. And as he tried to steer the car over the curb, he felt himself becoming unconscious and he thought he had a convulsion. All right. So, this is, by the way, talking about Actus Reus, which is about what somebody did, not necessarily what somebody intended to do. A lot of crimes have an Actus Reus and a mens rea requirement, meaning that somebody had to actually have done something illegal and they had to have a guilty conscience while they were doing that illegal thing, meaning that they had to have known that they were doing that thing. They don't have to know that it's illegal. They just have to know what they were doing, right? Okay. And so this is gonna be talking. This case is gonna end up be talking about what he actually did, right? Like he tried to steer the car over the curb as he felt himself becoming unconscious. Okay, so remember that there's three sides, right, to every case. There's the defendant, the plaintiff in this case, which is the prosecutor representing the government, and then there's the judge. And the judge has their general interest is to get as many cases out of their courtroom as quickly as possible. Like they have so many cases, it's not even funny. They of course want to be accurate. Like the reputation matters a lot to them, but the quicker they can get this out, the better, right? The prosecutor has, and by the way, I guess I should start here. Prosecutors are, as far to my knowledge, they're all hired by the government. So they represent the government and they're paid by the government, like the government employees. And a lot of them go on to do, political careers and stuff afterwards. So it's, their interest is in being able to say, I defended the public against these people, and if they had their way, they probably say against these monsters, right? So to them, cases that involve death or other dastardly crimes like assault and things like that, you know what I'm talking about. Those are the kinds of cases that they really want to take because it makes them look really, really good if they're able to throw somebody in jail for doing something egregious, right? Most are, they're really good, well-intended people. Let's start there. And just like really anywhere else, there are some that are highly motivated, is the easiest way to say it. They're highly motivated. And maybe they don't really have much of a conscience as far as repercussions are concerned. And by the way, this is the same thing in defense cases. So let's not even go there. There's also defense attorneys who are will try to get, if they could represent the devil, they probably they would do it. They charge extra, but they would do it, right? So there's the two extremes. Like there's prosecutors who would try to throw an angel in jail, and there's defense attorneys that would try to keep the devil out of jail. Most people are not in that extreme spectrum. Like most attorneys are just really actually pretty reasonable people. So if if they could ethically represent somebody, they try to keep innocent people out of jail, and they try to, um, they try to only prosecute the crimes that they think are noteworthy, not noteworthy, but legitimate, right? Maybe both. So in this particular case, this is kind of where I'm at, right? Like, and we haven't finished the case. I don't even remember how this ends, but I'm sitting here looking at this and I'm thinking about both the prosecutor and the defense attorney. Like, assuming this is true, which in all cases, whenever we're in law school, at least, we assume that all the facts are true. That was another thing that, like, it's funny because your instructors will tell you should not assume that the facts are true. You should assume that people are lying. You should assume that uh, maybe they got it wrong. And then when it comes time to do the exam, if you try to examine any of the facts that they gave you, like, you're gonna lose so many points. It's not even funny. Just this is what I'm talking about. Like, it's almost borderline sabotage the way that things are explained, right? So assume everything that the instructors put in the exams are true. It's a little tidbit of extra advice, right? So, like in this particular scenario, right? Like they said, and he tried to steer the car over the curb, and he felt himself becoming unconscious, and he thought he had a convulsion. We have to assume this is true. Like, don't even question it. Don't even, at least as far as a law school exam is concerned, don't even question it. Like, just assume he actually did in fact try to steer the car over the curb as he felt himself unconscious. Like, you have to assume that he actually was feeling himself getting unconscious, and he thought he had a convulsion. You have to assume that he was 100% truthful. And the way to think about this, because we all have our doubts, right? But as attorneys and as future attorneys, being law school students, you have to assume that the jury is correct. They have to, like if they came to this, then the jury decided that this was a fact of the case. Whether they're right or wrong, or yes or no, or left or right, like, they are correct. And our job is to operate on the law based on the facts that they decided, right? So it's not up to us to decide whether or not this is correct. So from the prosecutor's perspective, now we have to think, okay, this is true. Do we want to throw somebody in jail who was fighting becoming unconscious and was having a convulsion? Is that the kind of person we want to throw in jail? Like, there's plenty of other people that are doing things that are, heinous, that we actually do want in jail. Is this one of them? And if you have a good prosecutor and they have these facts, like, they'll let go of the case, right? Assuming that it's true, right? So if these facts were proven, they just wouldn't prosecute, right? At least not on this thing. And on the same note, as a defense attorney, you look at this and you think, okay, same thing, right? Like, the same general notion, like, the prosecutor should not be prosecuting this, and you have to have a relatively good relationship with the prosecutor, professional relationship with the prosecutor. We say, hey, look, like, this is not in the interest of justice. Like, this isn't the type of person that we want to punish. Like, you can't even say that this was a mistake. Like, this is less than a mistake. If you're having a convulsion, again, assuming this is true, if you're having a convulsion, you have very little control of your body. Like, your body's just doing its thing. And that's how this person is operating. Meaning, that's what they're having to deal with. But that's going to be the big challenge, because, again, the role of the prosecutor is to decide whether or not they want to keep forward with this. So the only way that a prosecutor would know that this is like a fact, if you will, is um, aside from the aside from the jury deciding, which it wouldn't do until the end of the case, is if both their experts and the experts of the defense are both saying, yeah, he was having a convulsion. So if there's no experts, excuse me, if there's no expert saying, I don't think this person was having a convulsion, there's not really much that the prosecutor can do at that point, Anyway, let's keep going. So then it says, he was aware that the children in front of his car, excuse me, he was aware that the children were in front of his car, but did not know whether he had struck them. So this is what we're talking about, like actus reus versus mens rea, right? So that mens rea would be whether he intended to have contact with them in a manner that would end up harming them. And the actus reus would be the actual motion, and he knew that it was happening, right? So the actus reus is much more objective than anything, and the mens rea tends to be more subjective. So mens rea is almost always examined by like psychologists, right? Determining whether or not that person had the frame of mind. Did they know what they were doing? Did they intend to do it? Like, was this an involuntary movement, or was this person insane? That kind of thing. Okay. Defendant then proceeded to relate to Dr. Wetcher his past medical history. In 1946, he was treated in the same hospital for an illness during which he had some convulsions. So this person has a history of convulsions, right? So that's gives us a clue as to why he thought that he was having a convulsion, and maybe why he tried to steer over to the curb. Okay, several burr holes were made in his skull, and a brain abscess was drained. Okay, what's a brain abscess? Like, what is this? Google to the rescue. Okay, it's a serious infection inside the brain, forming a pocket of pus and swelling that can damage brain tissue. So this guy's got brain damage. Like, he has a history of brain damage, right? All right, yeah, was drained. So following his operation, defendant had no convulsions from 1946 through 1950. In 1950, he had 4 convulsions. Okay, and this, let's see, when did it happen? 1950. When did this occur? '55. So 5 years later, after he had 4 convulsions, right? Like, okay, so it wasn't like he started having convulsions and then the next day this happened, right? So he had some sort of like notice, and he was still driving. Okay. So this is where the prosecutor is like, okay, maybe you didn't intend to do it, like, but you really should have known better. Like, you shouldn't be driving, bro. Like, we want to make sure that people like you are not driving. Maybe we don't want you in jail necessarily, but we want you not driving. Okay. He had 4 convulsions caused by scar tissue on the brain. From 1950 to 1954, he experienced about 10 or 20 seizures a year, in which his right hand would jump, although he remained fully conscious. So, okay, yeah, these convulsions are like he's having involuntary movements, right? In 1954, he had 4 or 5 general seizures with loss of consciousness, the last being in September 1954. A few months before the accident, 1954, a few months before the accident. Thereafter, he had no more hospitalization, a spine tap, consultation with a neurologist, and he took medication daily to help prevent seizures. On the basis of this medical history, Dr. Wetcher made a diagnosis of Jacksonian epilepsy, and was of the opinion that the defendant had a seizure at the time of the accident. Okay. I don't know, by the way, if Dr. Wetcher is a like, are they the defendant's expert or are they the prosecutor's expert? Like this stuff is relevant, by the way. It shouldn't be relevant because experts are supposed to be objective, but yeah, experts like to, they're human, so they like to not bite the hands that feeds them. So you get more work. All right. Defendant was indicted and charged with violation of section 1053-A of the penal law. The statute provides, okay, this is going to be important. A person who operates or drives any vehicle of any kind in a reckless or culpably negligent manner, whereby a human is killed, is guilty of criminal negligence in operation of a vehicle resulting in death. All right. Yeah. Okay. So we're talking about criminal negligence here, which that is different. It's not like they're not being charged with murder, which does have an intent component, meaning that you have to show mens rea. But this does not require a mens rea. This just requires you to do something really dumb. By the way, whenever you hear the word negligence, you law's a funny thing because we like to use big words, right? But whenever you hear the word negligence, just think, did this person do something really dumb? Or was it really dumb that this person didn't do something that they should have? That's negligence. Let's keep things simple for now, okay? That's easiest way to know if somebody did committed negligence. There's more to it from the legal aspect, but that's a pretty good starting point. All right. So let's go over this again because the statute is really important. Okay, a person who operates or drives any vehicle of any kind in a reckless or culpably negligent manner. Like, okay, what is reckless, right? In the terms of legal, like is driving when you know you have a history of seizures? Is that reckless? There's gonna be a whole bunch of history on that, by the way. Like that's how they're gonna decide, right? But culpably negligent, like negligence doesn't require you to even know what you're really doing. So that's a really big deal. And the reality is that if you know you have a history of seizures and that you can't control your body, like driving during that time is not a good idea. Like clearly, right? It doesn't take a genius to know that. Okay. And so here's where it is, right? And whereby a human is killed. This wording is like, this is where this person's gonna, like, this is where the defense attorney's gonna be like, oh no, right? And where the prosecutor's like, I got him. Because it doesn't require the person to know they're killing somebody. It doesn't require them to know that they're doing something that's gonna get somebody killed. It just requires that somebody died. Yeah. So is guilty of criminal negligence in the operation of a vehicle resulting in death. And I'm gonna guess they're gonna decide that yes, that was criminal negligence. Let's see. It could be wrong, but let's see. Okay. The defendant now argues that the lower courts should have sustained his demur. This was in New York. I don't know. Okay. Anytime I see the word demur now, I think California, but I guess they use it in New York too. Cool. All right, to the indictment on the grounds that the indictment here does not charge a crime. Okay, interesting. The indictment states essentially the defendant, knowing that he was subject to epileptic attacks or other disorder rendering him likely to lose consciousness for a considerable period of time. Okay, so it looks like they're arguing that the indictment itself is badly written. It's basically like that's the way I'm reading this. Like, it was badly written and therefore I shouldn't be charged for a crime. Let's see what happens. Okay. Was culpably negligent in that he consciously undertook to and did operate his Buick sedan on a public highway. So this is what I was talking about earlier. Like, they're saying that it wasn't necessarily at that moment that he did something that was negligent or reckless, but that it was the decision to get into a car and drive when they know what kinds of conditions they have. They're saying that that was it, right? Okay. Emphasis applied. And while doing so, suffered such an attack, which caused said automobile to travel at a fast and reckless rate of speed, jumping the curb and driving over the sidewalk, causing the death of 4 persons. In our opinion, it is this clearly states a violation of section. So this is basically saying this person's guilty, right? In our opinion, this clearly states blah, 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 okay, of the penal law. The statute does not require a defendant must deliberately intend to kill a human being. This is what we're talking about, mens rea, right? So they're saying that the statute is what we call a strict liability crime, meaning if you did it, it don't matter if you intended to do it. If you did it, like, you're done. Like, you're guilty, right? For what would be murder, which, as we mentioned, as we talked earlier, murder does have an intent, right? But criminal negligence does not. Okay. Nor does the statute require that he knowingly and consciously follow the precise path that leads to the death and destruction. It is sufficient, we have said, when his conduct manifests a disregard of the consequences which may ensue from the act, and indifference to the rights of others. No clear definition applicable to hundreds of varying circumstances may arise can be given. Under a given state of facts, whether negligence is culpable is a question of judgment. Okay, so they're citing another case, by the way. Like, in this other case, People versus Angelo, they said these exact words. This is how precedent is built, right? Like, these exact, boom, right there. So if you look at People versus Angelo at section 457, 451 through 457, it's going to say these exact words, right? At least if it's written correctly, like, it's going to say that. Okay. Assuming the truth of the indictment, as we must know in a demur, this defendant knew he was subject to epileptic attacks and seizures that might strike at any time. This is what we're talking about, right? Like, it was really dumb to drive when you know that you have these kinds of things. He also knew that moving motor vehicle uncontrolled on a public highway is a highly dangerous instrumentality capable of unrestrained destruction. A little heavy-handed in the wording, but okay. With this knowledge, and without anyone accompanying him, he deliberately took a chance by making a conscious choice of a course of action in disregard of the consequences which he knew might follow from his conscious act, and which this case did ensue. Okay, so what they're saying is the deviation that he made, where he course corrected, knowing that he was having an attack, was evidence used against him, basically. So the fact that he tried to not hit somebody on the road was what they are using against him. Like, okay, so let that sink in, right? Like, yeah. So him trying not to cause more destruction is exactly what they're like saying we should throw him in jail, at least in this little piece, right? Okay. How can we say as a matter of law that this does not amount to culpable negligence within the meaning of this section of 1053-A? To hold otherwise would be to say that a man may freely indulge himself in liquor and in the same hope that it will not affect his driving. Okay, I want you to really pay attention to like what they're doing here, okay? Because again, you got to look at the prosecutor's perspective, the defendant's perspective, and the judge's perspective, right? Like, remember that the prosecutor's job is to throw people in jail. Like, period. Like, that's their job, right? If they have a case before them and their boss says, I want you to prosecute this case, that's what they're supposed to do, right? And on the defense side, you're supposed to try to keep people out of jail, right? So in the judge's role is to try to be like the reasonable one in the room. They're supposed to listen to both sides and say, okay, yeah, you got a point, and you got a point too. Okay, yeah, I mean, let's meet somewhere in the middle. Like, okay, I think you're being a little heavy-handed here, and I think you got a point. So let's go this way. Or like, I think you're being a little heavy-handed, a little overzealous, and maybe you got a point. So let's back off there. Okay, they're comparing this guy having epileptic attacks to somebody that's just a drunk. That's a little different, you know. Like, I'm pretty sure if this person had a choice between having epileptic attacks or not, they would choose not to have epileptic attacks. Like probably, like if you got paid to have epileptic attacks and you got not paid to not have epileptic attacks, you would probably choose to not get paid to not have epileptic attacks. Whereas alcohol, like, you have to buy it. It's not for free. So you got to think about that state of mind too, right? Like, so we're, again, remember, this is 56. This is 1956. And in 1956, we weren't real nice to people with medical issues. Not really, especially not mental stuff. Like, we understood the person who had their like leg blown off in war. We understood that. We could see it. Person's missing a leg, cool. But any sort of mental disorder or even neurological disorder in this case, like, we're talking about, I forgot the name of the condition, but we're talking about having an infection in your brain and like having pus and like having to get drained out, having seizures and stuff like that. That's pretty serious. That's pretty serious. That's a pretty serious medical condition, right? And I don't want to say they have no mercy, but they're comparing him to a drunk, right? Like, and I don't know if at that time you just like considered drunk people to be um, like standard every day, like everybody does it. Maybe, I don't know. But like the choices are clearly different, clearly different. They're like, but again, we're treating as if it's the same. So let's see if they do something about that or not. Maybe they will, maybe they won't. I'm not sure. Like I said, I haven't seen this case in a while. I don't remember it very well. Okay. And if it later develops that the ensuing intoxication causes dangerous and reckless driving resulting in death, his unconsciousness or involuntariness at the time would relieve him from protection under the statute. So again, they're claiming that being drunk and then taking the keys and driving is the same as having a medical condition that spans over years in the example of epilepsy and then driving. Now, clearly, a defense attorney is going to think, okay, yeah, but these are things that are unpredictable. Like, when you drink that you could have that you're gonna get drunk. Like that. Like, that's, I don't want to say that's the goal, but that's kind of the goal, right? Like, that's the goal of drinking is to depress your emotions, if you will. Like, it's a depressant. It's classified as a depressant. So the goal is to dull some physical and emotional responses, which is bad for driving, clearly. Um, but in terms of epileptic attacks, they could happen at any time, and it's like, they said how many he had, right? It's not like he could see them coming. It's not like he woke up that morning. He's gonna think, and he was thinking to himself, I'm gonna have an epileptic attack. I think this is a good day to go out for a Sunday drive. It's very different, right? But the court is treating it like it's the same, at least in this case, and maybe, at least so far, maybe later on when they're having a concurrence that it will be different. But okay, his awareness of a condition which he knows may produce such consequences as here is, and his disregard for the consequences renders him liable for culpable negligence, as the courts below would have properly held. To have a sudden sleeping spell, an unexpected heart attack, or other disabling attack without any prior knowledge or warning thereof is an altogether different situation. So the only, at least in this particular section, what they're really differentiating is that he has some history. So the reason that they're looking at, holding this person responsible for a crime is that this is not his first time having some sort of symptom. Like, this is not his first time having an epileptic attack. So, like, one in the, it's like a lot of states have a one free bite rule for dogs, right? Like, meaning that the first time that a dog bites somebody, like, you're probably not gonna get held responsible for it. But if the dog has bitten somebody once before and now they're biting somebody again, like, we're not gonna say that you didn't know. Same thing, right? So in this case, they're saying if this was his first time getting an epileptic attack, we would say that he wasn't negligent. But since he's had epileptic attacks before, even if they weren't when he was driving, then we're going to say that he was criminally negligent. At least that's where we're at right now. Okay, and there is simply no basis for comparing such cases with the flagrant disregard manifested here. Accordingly, the appellate division properly sustained the lower court's order overruling the demur, as well as its denial of the motion in arrest of judgment at the time on the same ground. Okay. So now there's another justice, Desmond, who concurs and also dissents. Now, dissents in part, concurs in part and dissents in part. So they kind of agree and they kind of don't. And judges are allowed to do that. They're even allowed to agree and disagree with themselves, which is a little loco if you think about it, right? Like they could be quoting themselves later and they could be disagreeing with themselves, which is okay, whatever. It's pretty amazing though. Okay. So this is what they said, right? And by the way, looking at these is, especially if you're in your first year of law school, like looking at these concurring and dissenting opinions will give you those extra bit of perspective that you might miss otherwise. Kind of like what we're doing here, right? Like I'm telling you, this is what I would be looking at. This is what I'd be thinking about. Like they're gonna do the same, though maybe not in the updated fashion as we are right now. So this would be, for its time, 1956. Anyway, here we go. I think the indictment should be dismissed because it alleges no crime. Well, they're pretty straightforward, aren't they? Okay, so they dissent as to the result, at least, right? Okay. The defendant's demur should have been sustained. So this was an objection. The objection should have been, actually, this was a motion. Yeah. So they're saying that the motion should have been sustained. An indictment that charges the defendant knowing that he was subject to epileptic attacks or to disorder rendering him likely to lose consciousness, suffered an attack and a loss of consciousness while caused the said automobile operated by the said defendant. I love the way that people used to write. Like, it's so different. I was like, what? Okay, let's back up a little bit. Suffered an attack and a loss of consciousness which caused the said automobile operated by the said defendant to travel at a fast and reckless rate of speed. Okay. And to jump a curb and run onto the sidewalk and thereby striking and causing the death of 4 children. Horrible as this occurrence was, okay, I love that they're talking about this, actually. This is something that I don't know how many law schools talk about this. They definitely should. But again, there's politics here, right? Like the real reason, if you will, the real reason why we're even looking at this case is because 4 children died. If it was like an elderly person or, somebody who was like, in their 20s or 30s or whatever, nobody would care. But this prosecutor was like, 4 people died. 4 children died, and that looks really sexy on a headline. So they were going to take this case, like whether they should have or not. They were like, I'm going to say that I stood up to defend the lives of 4 children. You know, they will probably not mention that they were defending it from a person who was having epileptic attacks, but that's besides the point. On their like report card of things that I did this year, it will say I prosecuted somebody who killed 4 children. That's what it's going to say. And it's important to take note of that, because this is how cases are, to an extent decided, whether it's even going to be taken or not. Okay. Horrible as this occurrence was, and whatever necessity it may show for new licensing and driving laws, nevertheless, this incident charges no crime known to the New York statutes. Our duty is to dismiss it. So this judge is like, yeah, 4 children died. That is absolutely horrible. But you want to throw somebody in jail for having epileptic attacks. And there is no law that has a history of showing that we would have considered this to be a crime. So I appreciate what you're doing, but I think this is wrong. That's kind of basically what he's saying, right? The essentials of the crime are, first, the vehicle operation in a culpably negligent manner, and second, the resulting death of a person. This indictment describes the way in which defendant is supposed to be offended against that statute. Yeah, okay. That descriptive manner shows the defendant did not violate 1053A. Okay, so what they're saying is, which by today's standards, it probably looks correct, right? Like, this person had a license to drive. They had nothing legally barring them from driving. And they drove in a lawful manner until an emergency came up. And when that emergency came up, they tried to rescue it. And this is kind of what we were talking about earlier. Like, they were using the evidence that he tried to move off of the road, because it started out on a public highway, and then he felt like he was starting to have his convulsion, and he was like, I gotta get off the road, basically is what it said, right? And it just so happened he tried to get off the road and onto the sidewalk where people were walking, which I guess a really responsible thing to do would be to just stop the car and put it in park and turn it off without driving off the road. But when you're having a convulsion, you're not thinking straight. Or when you're having a heart attack, you're not thinking straight. Like, you're just doing stuff, right? And maybe that stuff is the right move, and maybe it's not. So, and I guess I should also add this here. Making the right decision when there is an emergency is it's much more scrutinized in tort law, where the punishments are civil, meaning it's going to involve money of some sort, or some sort of other remedy that does not involve jail. But we really, really protect people against sending them to jail for things that, even if they did something they should have known better, wasn't intentional, right? Like, there are still crimes that don't require you to do something intentionally that will still send you to jail, but we're not talking about that at this moment. Or actually, I guess we kind of are. We're talking about the Actus Reus, but okay. The excessive speed of the car and its jumping the curb were caused, says the indictment itself, by the defendant's prior attack and loss of consciousness. Okay. Therefore, the defendant is accused of is not reckless or culpably negligent driving. This is probably actually like what is really saving him, the culpably, right? Like, so culpably as a word, I mean, we'd have to look it up, but it really kind of hints at saying like this person had to have some sort of criminal state of mind. It's not just the negligence itself. Otherwise, it would just be reckless or negligent driving. But this word changes the game, right? Oh, here we go. I love that they went into this, which necessarily connotates and involves consciousness and volition. Boom. This right here, now we're talking about mens rea. Like, they're saying that's what this judge is talking about, this justice is talking about, is this isn't just an actus reus. It's this statute, this culpably word, changes the operation. It's not just about doing something dumb. It's about knowingly doing something, right? There has to have been some sort of intent. Okay. The fatal assault by this car was after and because of the defendant's failure of consciousness. So they're saying, this person had an attack. They had an emergency. They lost consciousness. Like, what were we expecting them to do in that moment? That's really what it's saying, right? To say that one drove a car in a reckless manner, in that his unconscious conditions caused the car, conscious condition caused the car to travel recklessly, is to make two mutually contradictory assertions. Yeah. Okay. No, this is perfect. They're saying you either did something on purpose or you didn't. Like it's not both, right? So mutually contradictory. Like it's one or the other. Okay. Oh, perfect. It goes into it. One cannot be reckless while unconscious. Well, I would disagree with that. You can do some reckless stuff while you're unconscious. I have been accused of, making sudden movements in my sleep and like smacking somebody. So I guess you can do it, but not while driving, at least not in this case. One cannot, while unconscious, operate a car in a culpably negligent manner or in any manner other than manner. What? In negligent manner or in any other manner. Sorry. Yeah. The statute makes criminal a particular kind of knowing, voluntary, immediate operation. It does not touch at all the involuntary presence of an unconscious person at the wheel of an uncontrolled vehicle. To negative the possibility of applying Section 1053-A to these alleged facts, we do not even have to resort to the rule that all criminal statutes are closely and strictly construed in favor of the citizen, and that no act or omission is criminal unless specifically and in the terms so labeled by the clearly worded statute. Okay, so they actually did touch on something really important here, and that is to say that the government makes the rules, and because we allow government to make rules, we expect law to operate in a way that is favorable to the people whom the rules are enforced on. And that's why there's so many protections for people, right? So, and that's what they're talking about. Like, it's supposed to be written, it's supposed to be construed in light favorable to the defendant, right? Numerous are the diseases and other conditions of a human being which make it possible or even likely that the afflicted person will lose control of his automobile. Just what is the court holding here? That a driver whose brief blackouts lets his car run amok and kill another has killed that other by reckless driving. I mean, just what is the court holding here? That a driver whose brief blackout lets his car run amok and kill another has killed that other by reckless driving. Has killed that other by reckless driving. Okay. But any such recklessness consists necessarily not of the erratic behavior of the automobile while its driver is unconscious, but that his driving at all when he knew he was subject to such attacks. Yeah, okay, we talked about that earlier. Thus, it must be that such blackout-prone driver is guilty of reckless driving. Okay. Vehicle and Traffic Law, Section 58. Whenever and as soon as he steps into the driver's seat of the vehicle. Okay, yeah. So they're saying that whether he killed somebody or not, that if we construed the law in the way that it was, that he would have been guilty. Okay. Every time he drives, accident or no accident, he is subject to criminal prosecution for his reckless driving or for the revocation of his operator's license. Yeah. Okay. The demurrer should be sustained and the indictment dismissed. Yeah. All right. So that is the first of many criminal cases that we'll be covering. Yeah, I mean, this is all about intent. It's to say that while the action is important, the intent is also important, depending on the statute. There are some statutes that have no intent requirement. We'll get into those later, but yeah, here we go. All right. If you have any suggestions as to what you liked and what you didn't like, I'm always open to new ways of doing things. So let me know what you liked and what you didn't like. All right. Thanks. See you next time.